The case that is being reviewed in this paper is Eng Chi Choi and Better Symbol 9 Berhad. This case has one issue in regards to civil procedure, which is whether there is substantial non-compliance of rules when filing a writ action first instead of originating summons. The issue arises in this case pertaining the abuse of court process is within the context of Order 88, Rules 2, Rules of Court 2012 under the mandatory provision.
Assalamualaikum and hi, my name is Amylya Afriena binti Nursyazriena 265008. The facts of the case is that the plaintiff has brought an action claiming that the second defendant conspired against the plaintiff and also the first defendant company interest by praying for the first defendant company to be wound out and appoint a liquidator in accordance to Section 181 of the Company Act 1965. Then, the defendant filed an application to strike out the plaintiff claim on the ground that the suit was an abuse of the court process. The defendant argued that there was a substantial non-compliance of the court or rules as action was brought by way of writ, and also a hybrid action was commenced whereby the plaintiff prayed for a winding up of the company and also relief under the Section 181 of the Act. The defendant contended that by filing a writ instead of originating summon, there has been a substantial non-compliance of the rules.
Grounds for appeal might be based on the facts of law or an issue of law. In this case, the parties fought over the questions of law. The defendant asserted that the plaintiff claim was not endorsed in the writ and the plaintiff's statement of claim did not reveal a plausible cause of actions against the defendant, and that the lawsuit was thus frivolous, vexatious, and abuse of the court's process. This statement of claim should include the legal cause of action, the material fact that support the claim, and a section stating what orders the plaintiff seeks to be granted as a result of bringing the claim. As previously stated in the case of Law Holdings in Berhad, the simple fact that the plaintiff is unlikely to prevail at trial is not a basis for striking out a claim as long as the statement of claim discloses some basis for action. In this case, it is unambiguously stated that the plaintiff met all that standards set out by the ROC. As a result, there is no basis for dismissing the dispute entirely. This matter will require careful attention and will only be resolved by taking viva voce evidence at trial, which will be accomplished through the summoning of witness and the cross-examination. When a claim is manifestly unsustainable, as in Bandar Builders in Berhad, the summary procedure may be utilized. The judge concluded that the summary process is inapplicable where the facts and questions addressed not to be disputed or need to be resolved by cross-examination of witness or when a significant debate is required. In conclusion, the strikeout appeal on this application being dismissed considered a proper decision. At the end, this case shall bring to the trial instead of striking out the contention made by the plaintiff.
Order 5 Rule 1 has stated two modes of commencing proceeding where first to writ and second originating summon. For writ, it must concern on substantial dispute of fact, where for originating summon, it must be a case regarding any dispute under any written law. So in this specific case, the matters covered under Companies Act, which is a written law. So based on Order 5 Rule 3 of ROC, the mode of commencing proceeding must be made to originating summon. Further, in Order 88 Rule 2 has stated that any matter specifically covers under Companies Act except for warning, approach, and capital action, the mode of commencing proceeding must be made to originating summon. And even though there is a substantial dispute of fact, it still must be made to originating summon, because in this situation, Order 88 can be used where it allows the court to call any person for cross-examination in order to solve the problem of substantial dispute of fact. So in this situation, the maxim general law, the special rules, and the regime will be used, where it means that general law will not take precedence over special law, which means that if there is a law specifically covered on certain matter, it will prevail over the general law.
In conclusion, procedural matters must be noted as their non-compliance may affect the claim. In this case, the plaintiff used a writ instead of a summon as required under Rule 88 of ROC. This action resulted in significant ROC non-compliance. The plaintiff's lawsuit must be dismissed due to abuse of the court process. As we can see, non-compliance has higher impact on the applicant as the court may find against them. Thank you.